court came out, issued this protective order in the Diddy case, so they can give a bunch of stuff that could be problematic. But this is where stuff will be sealed. All visual depictions, including any photographs, films, video, or any other sexually explicit conduct or freak-off nudity, will be designated as attorney's eyes only. Does Diddy get to rewatch his greatest hits? The defense, obviously, from Diddy, they don't want anybody talking about this stuff either. The Diddy case is getting locked down. We have a new protective order that has come out from the judge, guiding us on how evidence will be reviewed, who can see it, when they can see it, how they can see it, can Diddy see it? If they have hard drives and terabytes of freak-off video files, do the paralegals get to see that stuff? Does Diddy get to rewatch his greatest hits? Probably not. Let's dig into the protective order to see how this material will be disclosed and rather not disclosed. The court came out, issued this protective order in the Diddy case. Remember that we're in the Southern District of New York, same place where a lot of other cases have been brought, Weinstein, Maxwell, and more. But this came out from the judge, Honorable Arun Subramanian, and this is a new judge after the original judge got reassigned. There are some redacted components here, not much, but we're talking about some pretty troubling allegations that involve sexual materials that will involve victims. And so we're trying to protect identities and limit the harm that can befall those who are going to be injured by this case. So we're balancing those interests against the public's interest in making sure that justice is done, making sure that the people responsible for the actual criminality are brought to justice, because we see a pattern here in particular out of this court where Ghislaine Maxwell gets prosecuted, but nobody else does. And they just put a nice bow on that when she gets a prison sentence. Everybody else goes free. So the public wants to keep an eye on this. And the court has come out and they said the following. All right, look, the government prosecutors will make disclosure to Diddy of documents, objects, information, electronically stored information as a courtesy and pursuant to the rules, and they must produce the exculpatory and the impeachment material as normal, right? All standard stuff. The government's disclosure material may include material that affects the privacy and confidentiality of individuals, would impede if prematurely disclosed, the government's ongoing investigation of uncharged individuals, would risk prejudicial pretrial publicity if disseminated, and may be produced with more limited redactions than would otherwise be necessary, and that is not authorized to be disclosed to the public or disclosed beyond that which is necessary for the defense of the criminal case. So they can give a bunch of stuff that could be problematic, but this is where stuff will be sealed. So in other words, they can disclose this stuff so the prosecution can give it to the defense, but it will be sealed. Certain of the government's disclosure material, referred to herein as the sealed material, contains information that identifies or could lead to the identification of witnesses who may be subject to intimidation and whose lives and persons will be subject to the risk of harm absent the protective considerations set forth herein. Now, certain materials in this case raise a particular risk of affecting the privacy and the safety of victims or witnesses. Yeah, especially if it's like a video, or the confidentiality of the investigations. And so the disclosure material that is produced by the government to the defense counsel, that is either, right, so there's a whole bucket of things that we're going to then label. If you designate it in whole or in part as attorney's possession only by the government, then we'll treat it differently. Or if it includes a bait or label stating attorney's possession only, or APO material, then it's going to be deemed. So APO material will be one bucket of material. So as the Diddy case unfolds, we're going to have a lot of evidence coming out, a lot of, additional names and filings and motions. And the question is, what are we going to be able to see? And it's going to matter how they categorize it, what bucket they put it into. Then there's going to be attorney's eyes only stuff, right? So not even Diddy can see. Certain materials in this case raise a more significant risk. Disclosure material produced by the government to the defense counsel that is either designated as attorney's eyes only shall also be sealed. And so it's ordered now that disclosure material shall not be disclosed by the defendant or by defense counsel, including any other defense, and shall be used solely for the purpose of this case, right? So non-disclosure of evidence, including preparation for trial, sentencing, any collateral attacks, anything, everything. The defense shall not post any disclosure material that is not publicly available on the docket in the above captioned case on any internet site including any social media site. Sealed material may be disclosed by defense counsel too, right? So if it is sealed, and a bunch of it will be, it may be disclosed to the defendant, who may only review such material in the presence of the Bureau of Prisons or law enforcement or defense lawyer or other personnel. So Diddy can only review these things under certain conditions. Now, personnel for whose the defense counsel's conduct is responsible for, right? So like expert witnesses or people at the law firm. Prospective witnesses only for the purposes of defending this action, provided that the defense counsel has reviewed this order with the witness and they know that they can't disclose any of this stuff either, and that neither the prospective witness nor any counsel will review any of these materials outside the presence of a lawyer. Each time a witness or their counsel signs and dates an attachment down there, the defense counsel will promptly file attachment A under seal and ex parte with the court. And so what they're doing is they're keeping like a disclosure log right here. Your name, signature, date. Who's reviewing materials? Let us know immediately. In the event either party wants to attach some of the sealed materials to the filings, then they should file it under seal, inform the court, we'll deal with it then. The sealed material received by the defense counsel shall be maintained in a safe and secure manner. It shall not be possessed by Diddy, so he shall not maintain possession of that, except in the presence of defense counsel, and shall not be disclosed in any form. And attorney's eyes only material that comes to the defense shall be maintained on attorney's eyes only basis, and the defense shall not share any AEO attorney's eyes only material or content of the material with any other persons, including Diddy. So the lawyers can't even talk to Diddy about the evidence except for any personnel for whose conduct the defense counsel is responsible. Now, all visual depictions, including any photographs, films, video, or any other sexually explicit conduct or freak-off nudity, will be designated as attorney's eyes only, regardless of whether it has been designated as such by the government. All right, so Diddy is not going to be seeing the Diddy videos. At the discretion of the government, certain attorney's eyes only material depicting explicit conduct or nudity may be made available for in-person inspection only. Like, come into a room, it's on this computer that's not connected to the internet and has no USB ports, so you can't copy the data. We're not sending you like a video file via email of Diddy's freak-offs. Now, the provision is limited. Such material located on Diddy's devices or cloud accounts, like if it was on his account, then he may view that under the following agreed conditions. The material is viewed by Diddy in the presence of a lawyer. It's on a device that's approved by the government. It's in a private room at the jail facility or other facility. Counsel ensures that the material will not be viewable by other incarcerated individuals. Don't want a bunch of freak-off videos floating around the prisons. Now, this is redacted, something redacted, redacted, redacted. These materials that involve these things will be made available for inspection only and not electronically produced. We're not even going to copy those. The defendant may view that in the presence of defense counsel at the courthouse while monitored by law enforcement, right? We got very sensitive videos. So they're, all right, you have like 5 cops standing around you while we watch you friggin' watch this video. Now, the order does not prevent the disclosure of the material in any hearing or trial, right? If it comes out in court, we can talk about it, but otherwise it should not be disclosed anywhere else. The government's designation of these materials will be controlling absent contrary orders. So if they say it's attorney's eyes only, it's attorney's eyes only. The parties shall meet and confer if there's disputes about this. The defense shall provide a copy of this order to prospective witnesses and people so they know it's serious. And except for this, the defense shall return to the government or delete or destroy any of this evidence within 30 days of certain timelines based upon appeals and so on. And so a serious order that was agreed upon by everybody, and it's in basically everybody's interest on this, kind of except ours. We all want to know what is in the evidence and how extensive this goes, because it's not just about Diddy and the victims, which it is obviously about the victims, but it's about the people who enabled Diddy and allowed the continual exploitation of the victims for decades and covered it up. And many people knew, many prosecutors knew about it. Many police officers got reports about it. Many charges were reviewed, considered, and declined. Why was that? And they're just going to put a bow on this with Diddy like they did with Ghislaine Maxwell or Harvey Weinstein? Give me a break. Now, I'm glad that there is some rectification of this, but what you'll notice is everybody wants to keep this under seal. The prosecutors don't want anyone talking about it. Makes their case harder if we know what's really going on. And the defense, obviously, from Diddy apparently they don't want anybody talking about this stuff either. So protective order entered, and this is expected, right? This is a major sex crimes case, and there's a lot of witnesses and victims, and things get very, very messy very quickly, and the implications can damage people. So you understand that much more so than issuing a protective order in a political case involving free speech and Trump's, electoral prosecutions. But much different situation here, and the case will be on lockdown. I'm sure we'll see a bunch of stuff filed. We'll see a ton of redactions, a bunch of stuff filed under seal. Regardless of where it goes, we'll be here to cover it.